The average price for a house in the UK is £296,000. But what if I told you that you could add anywhere between 5 to 8% of value to that property in the next 2 months with a guarantee? So that'll add up to at least £15,000 minimum. Using what's called permitted development rights, there are certain forms of development that landowners and property owners have a right to use that are open to them to ensure that they can build on their properties. Right now, permitted development rights have never been so expansive as they are today. The bigger picture is that the planning system is a very old system, it's lacking investment, but the pressure to build has not slowed down. There's a pressing need for housing in the UK, there's a pressing need for development, but councils who you need to get permission from, they're lacking investment. So this huge amount of development is needed, but the level of capacity at those councils is greatly reduced. What the government has introduced is a massive expansion to permitted development rights to essentially take the pressure off the council and allow the country to build at the same time. So in the last few years, permitted development rights have expanded so much that in particular, if you own residential properties or if you're a residential investor, then the opportunities available to you are huge right now. If you wanted to do a rear extension, a side extension, a roof extension, or maybe you wanted to do an outbuilding, or maybe you wanted to add 2 stories onto your property, all of these things you can do under permitted development rights now, which you could never do before. You can even now add new units. Normally that fell straight under planning permission. If you wanted to build any new units, you needed planning permission, that was a rule of thumb. But now, under permitted development rights, you can now add new units, which is a huge game changer for people. So I think that is a big change to the planning system and will hopefully lower the barrier of entry to investors that want to get assurance about investing into real estate. So this video is going to touch on all the different permitted development rights that you can do if you own a residential property. Like I say, they're expansive right now, so I hope you enjoy them. So permitted development rights are a whole way of sidestepping that whole process. It gives you certainty and an assurance about what you can do with your property so that you can know before you even apply that you're going to get permission, and you can also do the kind of calculations as to how much value that's going to add. Not that issue of officers refusing it or negotiating a reduction in the size of anything you want to do, because there's certainty. So this video is going to be walking through best strategies to do that. I'm going to be giving you at least four, and I'll be saving the best in my opinion till the end, so stick around for that. So let's start off with the first one. So before we get into each strategy, I'll just kind of set the scene of what permitted development rights are and the things to look out for in the context of this video. So all of these types of development come from a document called the General Permitted Development Order. It's a document that lists out all the different types of development you can do without planning permission, and within there's certain conditions. So that's where this comes from. The other thing is to look out for is Article 4 directions. It's a word that's thrown about and not many people really quite understand what it is. Article 4 directions restrict certain types of permitted development rights, not all. So as part of your research using this video, you'll need to find out what the Article 4 direction specifically restricts. It doesn't necessarily block all of them, so you may well be able to benefit from all the things I mentioned in this video, but there may be an Article 4 direction in place on your site that might not affect you. So just know that it's quite an important thing. Conservation areas, generally speaking, they restrict the amount of permitted development that you can do, so know that. Listed buildings do not benefit from permitted development. Neither do flats. It's a kind of a weird hole in the system. So if a house has been subdivided into flats, you can't benefit from permitted development rights. You can still apply for these things though, and quite likely get permission. But if you want to use the kind of the PD process, then flats don't really get the chance to do that. And the last thing to note is that even though these things are quote unquote permitted, you must always get a decision from the council to prove it so, because if you want to sell the house, when solicitors do their checks, they'll want to know that what you've done has got permission, and also you'll want to get to know if anyone complains. So if a resident complains, you'll have a certificate to show them. If you build something without permission, even though it is quote unquote permitted, you'll get enforcement officers involved, and it creates a whole issue that you don't want to deal with in the planning system. So always get your decisions from council. So that's just a kind of introduction and things you consider before we get into the strategies. So as I said before, this video is about permitted development for houses in particular, and all of the permitted development rights come from a document called the General Permitted Development Order. And the reason I'm saying that is because everything that's related to houses, or in the curtilage of a dwelling house as it says, is within part 1 of the General Permitted Development Order. So part 1 lists all of them. And within each part there's classes which tell you what types of development you can do. So class A, starting off with the first one, is about enlargement of your dwelling house. These are the things that you can do, like rear extensions, side extensions and roof extensions. There are kind of caveats within either of them, and the kind of headlines are that you can do rear extensions of 3, 4, 6 or 8 meters and that depends on whether you're a detached, semi-detached or terrace property, and also whether you're in a conservation area. The other one is side extensions, so you can extend sideways from your property, but to ensure that you're not more than 50% of the original dwelling house. The other class of note within part 1 is class AA, and this allows you to go up to 2 stories of additional height on your property if you're already above 2 stories, and if you're a single story you can go up to one story. For this class you do need something called prior approval, which is a kind of pared back planning process, so you still need to get an assessment needs to be done by the council to do this, but essentially the principle is established. You can't do this in conservation areas. The materials must be similar to the main house, and this is kind of true of all PD. When you're doing with extensions, they all have to be similar in design to the main house. So the design has to be the same. No windows on a side elevation. The roof pitch, so if you've got a pitched roof, you have to go up in the same pitch. You can't change the profile, and it has to be used for residential purposes. So that's just preventing you from changing the use of the upper stories for other uses. So those are the first 2 classes within part 1 for enlarging your house, and if you add all those things up together, particularly the rear, side and roof extensions, that's a lot of floor space. So class E is quite an exciting part of the general permitted development order. This deals with outbuildings. And I think it's very relevant, with COVID and how everyone now works from home. Everyone wants their work from home space. So outbuildings are a really nice way of kind of separating your work and home life. So you can build a building that is no bigger than 50% of the total curtilage, and it must not exceed 3,500 cubic meters, so whichever is less. Now the key to this is though that it has to be incidental to the enjoyment of the dwelling house, which is basically a funny way of saying that it has to stay within the single use of your house. So you can use it as a gym, you can use it as a swimming pool, you can use it as a home office, you can use it as anything you want. The point is here that you cannot kind of establish the principle here of building an outbuilding and then change the use, or do a title split and then sell it off as its own self-contained unit. That's a big kind of planning issue in itself, and I've been in appeals where that's the case. So just bear that in mind. So you can build an outbuilding, but it has to be incidental to the enjoyment of the dwelling house, but this adds a huge amount of value to your property. I've said if you stuck around to the end, I'll be giving you a bonus strategy. So this video is about how the rules of permitted development rights for houses, not only extensions to houses, but also the possibility of getting new houses. And that's where the kind of most exciting part of PD has changed in the last couple of years. So part 20, which is the last part that was added in the general permitted development order, is about the construction of new dwelling houses. And in there they've got a class ZA, A, AA, AB, AC, AD, and basically these are just listing the various types of buildings that you can add up to 2 stories on these buildings for new dwelling houses. So unlike before where it was just 2 stories for an extension for your own house, these are for the principal aim of adding flats to new blocks of flats in residential use. You can add 2 stories to commercial buildings, and then residential buildings that are either in terraced, detached, or if they're blocks of flats. So it's a really, in the grand scheme of things, the country is really struggling for housing delivery. So this is a huge step from the state government to give everyone assurance that we can add new houses on these sites. But the point is that the principle of adding 2 stories on a lot of the country has been established. So it's a really good opportunity for anyone that owns any types of these buildings, and it also lets you think creatively about a type of building that wouldn't necessarily be suitable for new flats. You now have the PD right to benefit from it. So part 20 is a really interesting part of PD, and one that can really be, if used well, can add immense value by adding, if you can add 2 units to on these sites, so you're talking about an incredible uplift in value. So part 20 is really good to be aware of. So that's it. So those are the best strategies to use for houses. Those are the rules for permitted development rights for houses. If there's anything here that you want me to expand more on, for instance, like if you want me to talk more about Part 20, I'm happy to do that. And there's also other parts of the General Permitted Development Order that I've done videos on as well, like Class MA Permitted Development, which is commercial to resi. That's quite an exciting part. So if there's any other strategies you want me to touch more on, please leave a comment below and I'll be happy to do another video on it as well. And until then, I'll see you on the next video.